Recognizing that the problem of racial discrimination infects the death penalty and persists in death penalty prosecutions is important, of course, in and of itself, but it's also important because it highlights much broader trends in the criminal legal system, where we see racism, in particular anti-Black racism, infect every stage of the criminal legal system. Despite real concerns about racial discrimination in jury selection, racial discrimination in the decision about who the federal government had chosen to prosecute for capital crimes, despite all these issues in case after case, the federal government under then President Trump went on this real execution spree, which is fundamentally inconsistent with where the country generally is going in terms of the death penalty and recognizing that the death penalty is not proper, is not appropriate, is not necessary, and that there is a significant risk of innocent people being executed. In fact, there have been some 180 exonerations from death row since 1976. And so to have the federal government, the sort of leader, be going against all of these important trends and where the evolving understanding of our fundamental values is quite disturbing. So there's a real opportunity now for the Biden administration to change course and to recognize that the death penalty is fundamentally inconsistent with our values, and that everyone who is on federal death row right now should have their sentences commuted. FURMAN versus Georgia was this 1972 case where the Legal Defense Fund litigated and took the case to the United States Supreme Court and convinced the court, albeit temporarily, to hold that the death penalty was categorically unconstitutional as then administered, because it was applied in a completely arbitrary way. There were no standards to guide juries in deciding who should be sentenced to death and who should not be sentenced to death. And so there was just this completely capricious application. And in addition, one of the factors that we did know played a significant role then, just as it does today, is race. So in a 5-4 case, the court held that the death penalty, as then applied, was unconstitutional and essentially created a moratorium on the use of the death penalty for the next 4 years. Four years after FURMAN, in a case Gregg versus Georgia and some companion cases, the court considered statutes that states had created since FURMAN. And the states had essentially promised the court, hey, we understood what you said in FURMAN, and we're going to create new systems so the death penalty will no longer be arbitrary. And the idea was that these new systems were supposed to have real standards that did two things. One, that made sure the death penalty was reserved for truly a very, very narrow category of crimes. And then the second key thing was that states had to create systems where, before sentencing someone to death, jurors could have a full picture of someone. Unfortunately, since Gregg, we've seen that the promise that these states made have not been fulfilled, and states have continued to administer the death penalty in a way that is fundamentally arbitrary and racially discriminatory. If we are able to address that problem and work to end the death penalty entirely and to ensure that measures are in place to prevent racial discrimination, of course, in the administration of the death penalty, those same measures in terms of addressing the problem of racial discrimination in the administration of the death penalty can be used and must be used in every other part of the criminal legal system. So similar protections are in place, and we continue to work to root out this fundamental problem, which remains a fundamental American problem of racism and anti-Black racism in particular, infecting the criminal legal system.